Welcome to Checkpoint this Sunday evening. We're discussing the ruling by the Appeals Chamber at the ICC regarding the use of recanted evidence. We all know what that ruling was. Imminent collapse, we'll be discussing that and which way forward. I have my guests with me. We have Danston Omari here with me and Harun, Ndubi, as well as Elisha, Ongoya, who joins us from our Kisumu offices here in Kenya. I was going to say Nairobi, Kenya. All right. Let me start with you, Elisha. Talk to us a little bit about what this means. We're hearing words of a weakened case. In fact, it goes so far as to hear some comments like imminent collapse. Is that a correct assessment of this case after the ruling?
Two things, Yvonne, are important. One, it is the prosecutor who made an application to the trial chamber to have recanted testimonies of witnesses used as an integral part of her evidence in the trial of William Ruto and Sang. It must obviously have been that she regarded that or those pieces of evidence as being important. And therefore, with the decision of the Appeals Chamber that those pieces of evidence are not to be used and are to be expunged from the record, to an extent, her case is weakened. But to suggest that therefore that means there is imminent collapse, that is prejudging. Remember, there are material of other witnesses that are before the court, and the court is currently considering the motion by both William Ruto and Sang on whether or not they have a case to answer. That motion will be determined on the material that is before the court, of course excluding the testimonies or the statements of witnesses who have recanted their statements in line with the decision of the Appeals Chamber. But I think it's too early in the day to conclude that the case has imminently collapsed. That amounts to stepping in the shoes of the judges, where neither I nor you nor either commentator on this matter is competent or qualified to delve into.
Okay, all right. Thanks, Elisha. Danston, let me come to you. Without this evidence, is Bensouda able to satisfy the court beyond reasonable doubt? Remember, in her statement to the trial chamber, she talked about this evidence being crucial towards supporting a conviction. Does she now have, does she still have a case?
Well, in my own view, Bensouda is a very experienced politician and a prosecutor. She delivered evidence that was cross-examined, and in totality, she believed that that evidence is not sufficient to convict or to put William Ruto and Sang on their defense. That is why she went to shop and fish for Rule 68 to bring recanted evidence. In her own admissions, she says she does not believe that the evidence she has produced is really having enough probative value. She must get recanted evidence. If she has admitted, and you look at the history behind it, before the President Uhuru Kenyatta's case collapsed, she had indicated that she does not have enough evidence to sustain that matter. And within a week or two, she had filed a withdrawal notice of that case. So in my own perspective, the way I see is that she will go back to Article 53 to withdraw the matter, because the case has collapsed and the case, there is no case. She can't sustain any further ado.
Harun, do you agree?
Obviously, I disagree with my brother Danston here because of two important things. One is that any party to a proceedings in court will make the arguments they will do as robust as they can. But the point is that it's the judges to determine the veracity and the importance of the evidence brought before them. The evidence that has been brought to the court, even if Bensouda herself says she doesn't think that the evidence is strong, it is the court to evaluate that evidence and determine whether they can convict or not convict, whether they are going to put the defendants on their defense or not. The fact that she may have said certain things, which my brother here is happy about, that at some point she she withdrew charges against Uhuru Kenyatta. It's important to remember that so far in the case against William Ruto and Joshua Arap Sang, she already closed her case. So it's for the court to make a ruling. Let us wait for the court to determine what has happened. However, I needed to point out something important, I think, about the ruling from the appeals chamber.
Yeah.
There are those who probably think that it is because of the political propaganda, the political energy that we saw from Kenya, the prayers, the African Union Addis Ababa summits that have led to this determination. And I think it's important to point out that what has happened is a win, one for justice, a win for due process, a win for court process. But also, it's a loss in terms of those who expected differently, a loss for those who are seeking for the truth, because all the evidence needed to be brought to the judges for them to make a determination. However, like myself and many others have stood to say, let the court be the one to determine whether or not to admit the evidence rather than having political propaganda about it.
Coming from the ASP and the AU submissions, which in fact they did start out by acknowledging and saying they did not agree with the AU interpretation on this matter.
Actually, the appeals chamber said that there was no evidence, that there was a record of an understanding, like Kenya and the AU are pushing, that there was an understanding that the admission of the evidence under Rule 68 would be retroactive or non-retroactive. So that was a very important thing to say. Let the due process take its course, because that is what secures the freedoms of the powerful and the less powerful.
All right. Danston, it's interesting, and many people have noted that the appeals chamber did not take into account or did not address the issue of witness tampering, which is what Fatou Bensouda had talked about even when she was seeking to use the recanted evidence. And witness tampering is a serious issue in this specific case, isn't it?
Very well, it is a very serious issue. I've gone on record to have said that really when you look at the ICC per se, it's not a criminal court. It is a quasi-political criminal court. And the issues that are being decided in those courts, the balance of the political aspects and arsenal in place determines what happens there. When you look at the decision from the appeals chamber, it was very clear that applying a law retrospectively in itself, the amendment of Rule 68 is an illegality. And as my brother rightfully puts it, it is that the justice and the rule of law was upheld, because it could have become terribly an affront on the rule of law applying a law retrospectively. In my own perspective, the way I look at it is that the appeals chamber ignored the witness tampering. There is no evidence whatsoever that Bensouda provided for those witnesses to be tampered with.
Allow me to stop you there, because there are warrants of arrest for 3 individuals that we know. Paul Gisheru, Philip Bett, and Walter Baraza. There is also 4 other indictments that remain sealed. And it is my understanding of a court process that before you get indictments, there is some level of evidence. Are you therefore saying that the evidence was not enough even for the warrants of arrest to be issued against
When you look at the tone of the appeals chamber, it actually lambasted the trial court, that it overstepped itself, it became too overzealous, because either it is presided over by Africans, the office of the prosecutor and the judge Osuji. The appeals chamber was very categorical, and if the trial court looks at the decision of the appeals chamber, they will not proceed with the direction they are taken.
The
warrants have been issued. The warrants were issued.
So
the next question that will be raised, either to be referred in that court, in the appeals court, were the warrants issued because they deserved to be issued, or they were the warrants issued out of the annoyance that there was a perception that witnesses were being tampered with.
Can I answer my brother here? I think he's completely mistaken about something. The fact that recanted evidence or witness, or rather the non-use of recanted evidence or non-use of evidence of witnesses who are unwilling to testify, is not based on the fact that they were interfered with. It is based on the fact that they were not available to be cross-examined in the context of the due process of the law. The tampering of or with witnesses and the fact that warrants have been issued is a different issue completely. Indeed, even William Ruto and Joshua Arap Sang and any other person who would either be either the beneficiary or promoter of the witness tampering would still be charged with the offense of witness tampering, whether or not the evidence of that witness was used or not used. Okay. It's not a principle that the evidence must have been admitted first in the trial for them to have been charged or to have been accused with witness tampering.
Okay, I'd like to go to Elisha, but just before we do that, so you're talking about no evidence of witness tampering, yet we know of the murder of Mesha Kebe, who is supposed to have been and was claimed to have been a witness for Deputy President William Ruto.
So the question is, if there is a claim that the Yebe, who is alleged to be William Ruto's neighbor, was murdered, then who murdered him? Is it the ICC? Could William Ruto kill his own witness? Definitely cannot.
Nobody is making an accusation either way.
Yes.
My question to you was, you were categorical that there wasn't enough evidence to support witness tampering, yet somebody who's claimed to be a witness, Mesha Kebe, it's witness tampering of the highest level. He was murdered. Of that, there is no doubt.
That's what I was saying, Yvonne. There is was Yebe a witness at all? Two people are claiming Yebe was the witness. The prosecution says that is the witness. William Ruto claims that is the witness.
Is that not sufficient to start to question that there could be witness tampering?
So the question that we are asking, and the question from where I sit, is so simple. There must be the truth of whether William Ruto or Joshua Arap Sang was part and parcel of the tampering. In my own perspective, the appeals chamber has not mentioned anything to do with the tampering of the witnesses. Okay. Number two, the trial court, the lower court, has been overzealous with that aspect of witness tampering. If that was the reason as to why they went for recanted evidence, the appeals chamber has come out very categorical that there was that cannot be applied. So do we still pursue that line that there was tampering of witnesses? I don't believe that.